Hey everyone, I'm Ben Manny. I am one of the landlord-tenant attorneys at Pisgah Legal. Um, I'm here today to talk to you about the recent CDC order that is being called a Federal Eviction Moratorium. In addition to homelessness prevention and landlord-tenant law, Pisgah Legal also serves low-income individuals to help them meet their basic needs in a number of other areas. For example, if you are the victim of domestic violence, we can provide you services. If you have consumer debt, it's another area of our practice. If you need help accessing your public benefits, we have attorneys for that. If you need immigration help, we can also do that too. So there's been a lot of misconceptions and confusion about the CDC order, and hopefully I can answer some of those in the next 10 minutes or so. A few weeks ago, the President of the United States issued an executive order that gave certain administrative or executive agencies the authority to look into whether a moratorium is needed. Last week, the CDC issued a 37-page order that became effective on September 4th and runs through the end of this year. This is being called a federal eviction moratorium, but the key thing to remember is it's not truly a moratorium. What this order does is actually provide certain tenants a defense to an eviction in certain situations, okay? And we're going to go through where it applies, when it applies, what you need to do. It's also important to know that this protection is not given to a tenant automatically. The tenant has to take certain action in order to take advantage of this order, okay? What I tell folks, even in the best of times, that they need to do when they owe rent is the first step is you've got to communicate with your landlord. You've got to tell them, I know I'm going to be behind on rent. Here's how I plan on catching up. I think that advice applies now more than ever. The first thing that any tenant who is going to be behind on rent needs to do is communicate with your landlord. The CDC order applies only in evictions that are based on failure to pay rent. The order specifically excludes evictions that are based on damage to the premises, breaking a condition of your lease. So for example, if your lease says that you're not allowed to have chickens and you bring in some chickens, you can still be evicted for the chickens. It does not prevent evictions that are based on criminal activity that happen in the premises. It does not prevent evictions that are related to disturbing the health and safety of other tenants or neighbors. It only applies in cases where you were unable to pay your rent in full, okay? It applies all across the country. Except in states that already have a more restrictive moratorium in place than the CDC's order. That's not North Carolina. North Carolina had a brief window where evictions were not being filed. That has passed, okay? This moratorium does not prevent a landlord from filing an eviction based on failure to pay rent. This order prevents that eviction from going through the court right now. In January, when this order is lifted, we expect that the court will allow evictions to proceed for failure to pay rent unless the order is extended. So if you have court and you have provided your landlord a copy of the declaration and affidavit that this order requires, and we're going to go over the requirements for that in just a minute, you should go to court and you should tell the court that you've provided the landlord with a copy of the affidavit or declaration or whatever you want to call it. You maybe should consider going ahead and filing a copy of that declaration or affidavit with the court before you get there. The order says that is effective as to all phases of the eviction process. So, well, what does that mean? Some of you may know that in North Carolina, evictions are called summary ejectments, first of all. They're not called evictions. And they originate in the small claims court of North Carolina, okay? Either party, after small claims, can appeal their case to district court for a trial de novo, which means a new trial. If the tenant is evicted for failure to paying rent, typically what the law requires is that they file their appeal and pay a rent bond into court. So we do believe that when the order says all phases of the eviction proceeding, that it applies to that process as well. And it's certainly possible that a tenant who is unable to afford their rent bond and has provided a declaration to the landlord could take advantage of that. This is totally untested, though. This is all very new, and we don't know if a tenant who doesn't pay rent bond can be evicted for failure to do so as required by the general statutes of North Carolina. Similarly, if you are a month-to-month tenant and you are being evicted as a month-to-month tenant, we don't know if this order will put a stop to those evictions. Now, I tend to believe that if the only motivating factor in those evictions is failure to pay rent, I believe this order should be effective. But if there are other reasons that your landlord does not want to renew your month-to-month, week-to-week lease or whatever, that those evictions will go through. So, for example, if your landlord is selling their home, if there are sort of other disagreements that maybe wouldn't rise to the level of criminal activity, but you and your landlord are having problems, then that certainly is something that may go through the courts. If the motivating factor is only rent, we certainly think that it's a possibility that this moratorium might serve as a defense for the tenant, okay? Yes, you do. You still have to pay rent, and you still owe the rent. You have to do the best you can to pay whatever you can, okay? This moratorium does not remove a tenant's obligation to pay rent, okay? Well, first of all, it's a sworn declaration, a document. It has to be provided to your landlord in English, okay? And it says you swear to a number of things here. If you are dishonest about what is on this declaration, there are criminal penalties that are available, okay? Including jail time and fines, all right? So when you provide your landlord this declaration, you want to make sure that you're being honest. And what I'm going to do is I'm going to go through all the different little requirements on the declaration itself. I'm going to make sort of my best guess as to what it might mean and what I think maybe the best practices will be for tenants going forward. So the first thing that this declaration says, and by the way, I think that we are going to have a link to a copy of the declaration on our website, but I'm sure if you even just Google CDC order declaration, you can find it. So it's a sworn statement that first says, I have used best efforts to obtain all available government assistance for rent or housing, okay? So there are a couple of terms of art in there. Best efforts to obtain all available government assistance. Well, what does best efforts mean? I think that a common layperson definition is sufficient. Have you called the various resources in our community to try to obtain some rental assistance? Have you, talked to your county's Department of Health and Human Services? Have you called various churches? And can you prove it? If you are provided any documentation of your efforts to seek out rental assistance, I certainly think that it would be wise to show a court that along with a copy of the declaration, okay? The next thing is, and I think this is probably I think this applies to most people, but you have to swear that I either expect to earn no more than $99,000 in annual income for the year 2020. If you are married and filing jointly, you have to earn less than $198,000. So that's pretty self-explanatory. All right. The next piece, I am unable to pay my full rent or make a full housing payment due to a substantial loss of household income. Okay, loss of hours, loss of wages, layoff, et cetera, or extraordinary out-of-pocket medical expenses. And that's usually going to be calculated as around 7.5% of your adjusted gross income for the year. The medical expenses are. So one thing the order does not say is that that loss of income has to be related to the coronavirus in some sense. Now, I think most people who have lost income, it's probably going to be because of the coronavirus, but it seems that any reason is acceptable, okay? The next thing is I am using best efforts to make timely partial payments that are as close to the full payment as my circumstances permit, taking into account other non-discretionary expenses, okay? Non-discretionary expenses, food, transportation, utilities, okay? Again, we see that term best efforts. What does that mean? Well, it certainly means that you need to be looking at your budget and paying what you can. And if you can provide a paper trail of your best efforts to make partial payments, you're in a much better situation, okay? A history of partial payments is much better. Now, there are certain circumstances where maybe your landlord won't accept it. I think it'd be advisable to go ahead and document all the times you have attempted to pay your landlord a partial payment, all right? You have to swear that if I'm evicted, I would likely become homeless and need to move to a homeless shelter or double up with another family, move into a new residence shared by other people who live in close quarters, okay? So in Buncombe County, we have a very, very low vacancy rate. I think that many people in our county who are evicted are very likely to become homeless just because there's so few places to go. Anyone who would be thinking about moving right now is probably staying put. So I imagine that we will see that our vacancy rate will continue to stay very, very small. All right. So you also have to swear that I understand that I must still pay rent or make a housing payment and comply with other obligations that are in my lease, all right? So you have to acknowledge that you're still on the hook for all of this money, okay? And you have to acknowledge that I further understand that the end of this temporary halt is temporary halt on evictions December 31st. And that at that time, my housing provider may say, you owe me all of this money, okay? So we are telling folks that if you are going to try to take part in the benefits of this declaration, you've got to keep a copy of it. If you already have an action pending in court, you maybe should consider filing a copy of the declaration with the court. Be as honest as you possibly can. You know, don't fill out this declaration if it does not apply to you, because there are very, very serious penalties if you lie on this document, okay? Finally, do the best you can to seek out the rental assistance that's available in Buncombe. And if you need further advice on this, seek out the help of an attorney. You can always call Pisgah Legal. We have attorneys who are happy to talk to you about your situation. Thank you very much. Goodbye.